Welcome to our webinar on shared parental leave. My name is Lisa Kelly and I'm a solicitor here at Muckle in the employment team, and I'm accompanied today by Francis Cameron, who is an associate solicitor also in the employment team here at Muckle. Today's webinar is intended to be an overview of the shared parental leave scheme with a focus on how it will work in practice. We then intend to follow up with a further webinar in December where we'll pick up any changes to the regulations and we'll deal with any tricky issues and problem areas. So today's webinar we're going to cover what is shared parental leave, how does it interact with the current provision, so i.e. maternity, paternity, parental leave, how is it applied in practice, the notification of entitlement process, can an employer refuse shared parental leave, and what benefits, rights do employees on shared parental leave have? By way of introduction, in their 2010 election manifestos, both the Conservatives and the Liberal Democrats promised to introduce a more flexible system for both parents to take leave on the birth or adoption of a child. Detailed proposals for a new system of flexible parental leave were set out in the Coalition Government's consultation on modern workplaces, which was in May 2011. A detailed consultation was published in February 2013, followed by draft regulations. The Children and Families Act 2014 introduced a new entitlement for employees who were parents to take shared parental leave in the first year of their child's life or placement for adoption. These provisions will be supported by the shared parental leave regulations. They're currently still in draft, but few changes are expected, and they're due to come into force currently on the 1st of December 2014. Shared parental leave is due to apply to children whose expected week of childbirth begins on or after the 5th of April 2015, or who are placed for adoption on or after the 5th of April 2015. It's worth highlighting at this point that both BIS and ACAS have published guidance on shared parental leave to assist employers on this subject. Also, the ACAS guidance gives guidance to employees. So, what is shared parental leave? In essence, shared parental leave is a period of leave to care for a child after his or her birth or adoption. The new regime of shared parental leave will enable the mother of a new baby or an adopter to convert part of their statutory maternity or adoption leave and pay into shared parental leave and pay. These will be available for two parents to share, provided that they both satisfy the eligibility test, which Francis will come on to talk about shortly. Other than the 2 weeks of compulsory maternity leave, they will be able to decide how to split the leave and pay between themselves, as long as the reason for taking the leave is to care for the child. So, how does it interact with the current provision? Parents will not be obliged to take shared parental leave when it comes into force. The default provision will still be that 52 weeks of maternity leave or adoption leave, 39 weeks of which are potentially paid, will remain in place. The 2-week period of compulsory maternity leave, which applies from the day of the child's birth, will also remain in place, largely for health and safety reasons. However, additional paternity leave and pay will be abolished when the shared parental leave scheme becomes available, meaning that the only entitlement that the child's other parent will have, unless they engage in the shared parental leave scheme, will be 2 weeks ordinary paternity leave and pay.
Thanks, Lisa. I'm now going to talk about how shared parental leave will apply in practice, and more particularly if you're a business considering whether to allow your employees to take shared parental leave, how to determine whether they are eligible. So if you're a business and one of your employees comes to ask you to take shared parental leave, we've designed a flowchart here to try and explain the process you would be going through in determining whether that employee is entitled. The first question you'd be asking yourself, regardless of whether it's a woman or a man that comes to ask for shared parental leave, is does that employee requesting the leave have 26 weeks service at the 15th week before the expected week of childbirth? That's in a natural delivery. Or 26 weeks service at the 15th week before the week of notification in adoption. So those are the same provisions, or very similar provisions, that currently apply for a woman asking for maternity leave. If yes, does the employee have, as at the date of the child's birth, the main responsibility for the care of the child other than the other parent? That again applies to both the woman and the man, because if it's the man that's requesting the leave, again, you've got to be checking that they've got the main responsibility. The next question is this the mother or the main adopter, or is it the father or the partner of that person? Now bear in mind the partner might be the same sex, so it could be two women in a same-sex relationship. If it's the mother, the next question is to ask, is she entitled to maternity leave, and has she agreed to curtail her leave or return to work? The reason for that is the mother must have either decided to finish her maternity leave and move on to the shared parental leave scheme, or she must have returned to work in order for the father or the partner to go on shared parental leave. Now it can be that both partners go off on shared parental leave at the same time, but if that's the case, she must have decided to move on to the shared parental leave provisions or scheme, and she must have agreed to curtail the total leave. So that means after the initial 2 weeks leave that she has around the birth, she must have agreed that she is only going to take 25 weeks, for example, or 24 weeks, and that the father will be sharing her other half. She can't take the full year like she currently does on maternity leave. The next question for the mother is, has the father or the partner, so the other person, been employed or self-employed earner in at least 26 weeks of the 66 weeks immediately before the expected week of childbirth? And did they have an average weekly earnings over 13 of those weeks of not less than £30? Now the questions for the father or the partner are essentially the other way round. So the first question is, has the mother or the primary adopter, partner, been employed or self-employed earner in at least 26 of the 66 weeks immediately before the expected week of childbirth? And did they have an average weekly earnings over the 13 of those weeks of not less than £30? The reason why you're asking this question to the father or the partner is that it could be that the mum is self-employed actually, and it's the father that's employed and is taking the shared parental leave. The next question is then, is the mother partner entitled to maternity leave, maternity pay or maternity allowance, and has she either ended that by returning to work or agreed to curtail it? So again, if you've got a mother that's self-employed, she would be entitled to maternity allowance, and she must have agreed to curtail the maternity allowance if the partner is taking shared parental leave. The next question you'd be asking yourself as a business is, has the employee provided the employer with a notice of entitlement? I'll come on the next slide to tell you in a bit more detail as to what will go into the notice of entitlement. But essentially it's the evidential requirements that you'd be asking for of the employee to demonstrate that they're entitled to take this leave. And then as a business within 14 days you can then ask for evidence of the name and address of the other parent's employer, and a copy of the birth certificate or adoption documents. Once you've gone through that process, your employee that you're currently considering is entitled to shared parental leave, and you can't refuse to allow them shared parental leave altogether. However, it does depend a little bit on how they ask for, what type of shared parental leave they ask for. And Lisa will go into this in more detail in the coming slides, but there's a difference between whether that employee is asking for shared parental leave all in one block, because if that's the case, they're allowed to take that leave as of right, provided they satisfied the earlier eligibility tests, or alternatively, if they're asking for split periods of shared parental leave, so a block and then go back to work, then go off for another block of shared parental leave, then there are provisions around the employer refusing that arrangement and having to negotiate with the employee an alternative shared parental leave provision. So just moving back from my flowchart onto the slides, this is a slightly more detailed slide about the notification of entitlement. You remember from the flowchart that you get to a stage in the process where you're allowed to request from the employee notification of entitlement. Indeed, even if you didn't request it, they have to provide this. The notification of entitlement is a form that will have to be completed, and there are already ones that are circulating on the internet, draft ones. And in this form, the employee must set out what their partner's name is, the start dates and the end dates for the maternity, adoption leave and pay, the total amount of shared parental leave and shared parental leave pay available and how much of it will be taken by each person, confirmation that the childcare responsibilities are being shared, and a signed declaration from the partner with their name, address, national insurance number, etc., and showing that they satisfy the qualification or the eligibility criteria. So it's not dissimilar to the types of forms that you can request at the moment from a lady going off on maternity leave. The reality is, though, at the moment that most employers don't rely too heavily on the evidential requirements because it's fairly obvious if a lady's having a baby. But going forward, I think these notification and evidential requirements are going to be much more important for employers because it's not going to be as obvious if a man or a female partner, for example, in a same-sex relationship is asking for shared parental leave. I think employers are going to have to rely more heavily on these forms. Once you've got the notification of entitlement, employers can, within 14 days of receiving that, ask for a copy of the child's birth certificate or a document issued by the adoption agency demonstrating the relationship with the child and that the child is being born or adopted, and the name and address of the partner's employer. You can ask for this in any shared parental leave request, and it'll depend a little bit in practice as to which employers do request this and which don't. I suspect it might be that some employers choose to ask for this every single time shared parental leave is requested, or others might take the approach that they will only request this if they don't know the relationship status of that woman or man and they feel they need more evidence to prove it. Perhaps they're not trusting of the employee. Moving back on to Lisa's section now.
Thanks, Frances. So, can an employer refuse shared parental leave? So, as mentioned by Frances, upon receiving a notice to book leave from an employee, the employer's next step will depend on whether the employee has notified a continuous block of leave or whether the employee has requested a discontinuous block of leave. So, i.e., they've asked to go off on leave, come back to work, and then potentially go off at other subsequent blocks. A notification for continuous leave cannot be refused. However, if a discontinuous leave is requested, the employer will have 14 calendar days to discuss the proposal with the employee and to consider how and whether the request can be agreed. The ACAS guidance recommends holding a meeting where the employee is accompanied, even though there is not a statutory right to be accompanied at this meeting. Depending on the circumstances, there are 4 possible outcomes. The employer can either unconditionally accept the leave notification, even though it's discontinuous, or the employer can confirm an agreed modification to a leave notification. So in effect, what I would envisage there is that a meeting takes place, both parties explain their respective positions, and the parties come to an agreement. Or an employer can refuse a discontinuous leave notification, for example, because it just doesn't work in practice at that organisation, or because it's going to be very difficult to get somebody in to cover that employee's absence. Or finally, the employer can fail to respond and the default position of a continuous block of leave will apply. However, this obviously is not best practice not to respond, and also it's worthwhile being alive to the fact that an employee can submit a variation notice, which effectively would mean that you would have to go through the process again. The ACAS guidance suggests that the position should be confirmed to the employee in writing within 14 calendar days of the notification, regardless of the outcome. And it's also worth noting that if the employer and the employee don't reach agreement on the leave, the employee can actually withdraw their discontinuous leave notification. And in those cases where the employee withdraws their request, it won't count as one of the 3 notices that the employee has to book leave. So when I mentioned previously that an employee can submit a variation notice, employees have the opportunity to submit 3 variation notices. However, if an agreement hasn't been reached between the parties and the employee withdraws their notice, then that won't count as one of their attempts. So moving on, what benefits or rights do employees have when they're on shared parental leave? During shared parental leave, an employee is entitled to benefit from all of the terms and conditions of employment except for those relating to remuneration. If a redundancy situation arises while an employee is on shared parental leave, they, like a mother on maternity leave, must be offered a suitable alternative vacancy if one is available. An employee's rights on their return to work after taking shared parental leave will depend on how much shared parental leave they have taken, either on its own or in conjunction with any other period of relevant statutory leave. So relevant statutory leave includes shared parental leave, maternity leave, paternity leave, adoption leave or parental leave in relation to the same child. When an employee returns to work after a period of shared parental leave which, when added to any other period of relevant statutory leave in relation to the same child, is 26 weeks or less, the employee is entitled to return to the job in which they were employed before their absence. So that's very much like the position currently with maternity leave. However, if the period is more than 26 weeks, the employee will be entitled to return to another job which is both suitable and appropriate in the circumstances. Again, that's very similar to the current position in relation to maternity leave and additional maternity leave. It will be unlawful for an employee to be subjected to any detriment because he or she took, sought to take, or made use of the benefits of shared parental leave, or the employer believed that the employee was likely to take shared parental leave, or the employee undertook, considered undertaking, or refused to undertake work as permitted by Regulation 37, and that is that employees on shared parental leave can take up to 20 days where they return to work and it doesn't bring to an end their shared parental leave, and these are going to be known as split days, which in essence is going to be very similar to the current notion of kit days that we currently have. Similarly, if the reason or principal reason for dismissal is because an employee took, sought to take or made use of the benefits of shared parental leave, or the employer believed that the employee was likely to take shared parental leave, or the employee undertook, considered undertaking, or refused to undertake work as permitted by Regulation 37, the employee will be automatically unfairly dismissed. So that concludes our overview of the Shared Parental Leave scheme. Hopefully it's given you a flavour and you'll find our flowchart helpful in relation to the process for employees taking shared parental leave. As we said at the beginning, this session wasn't intended to be a detailed session covering difficult areas. What we would like to do is we're going to put our email details at the end of the presentation, and we'd like people to email us with any queries that they may have or expected tricky issues, and then we're going to do another webinar in December where we will aim to address as many of those queries as possible in the tricky issues webinar. So our email addresses are currently on the slide, and you can contact either Francis or myself with any queries that you may have. Likewise, you can contact us via LinkedIn or via Twitter or by going to our website. If you go onto our website, you'll also see that we put e-news up there which deals with any updates and articles, and it also includes details of our events and webinars. Both Francis and I very much hope that you have found today's webinar helpful, and we hope that you'll join us for the Tricky Issues webinar in December. But thank you very much for your time.